Hey everybody, it's time to debunk Old Fart Rants again. The impetus for this response, I'm going to respond to his retarded The Price of Freedom video. The impetus for this response was a friend of mine, Alan, uploaded a response, and I urge you to go watch that response. I urge you to go watch it in its entirety. It's a very good video where Alan calls out the old guy for a lot of his stupidity and errors. And Alan's got a lot of good videos. He's forgotten more about guns in probably the last 6 months than I know, and I've forgotten more in the last 2 minutes than Old Fart Rants knows. But I urge you to watch that. Those two videos I put up on your screen. Very good, very informative. Even if you're a novice, you will understand. Old Fart Rants has got a fetish for the AR-15. I thought it was funny. That wasn't even the weapon used in Orlando. Funny that he's whining about a weapon that wasn't even used. I mean, this guy's just, he's an idiot. I mean, he's got a lot of free time, so he's just going to crank out videos every time there's a mass shooting. But every time a black man murders another black man in Chicago, Baltimore, Detroit, or Compton, he won't crank out a video on that. If a drug dealer kills another drug dealer in an alley and they stuff him behind a dumpster behind Denny's, that's not going to get any play from him because he would be uploading videos constantly on that. But Alan did make one comment. Old Fart Rants, and I'll get to this in a minute, made a comment about if some drunk was, and this will be the main event of the video at the end, if some drunk pulled out a gun and started shooting, that wouldn't be good. Well, Alan said it would make a difference if someone else was armed, and I think it would. Because I don't think anybody in that nightclub was saying, gee, I hope Omar is the only guy with a gun in here. So, but as I'll go over at the end of this video, Old Fart Rants never looked at any statutes related to concealed carry and alcohol consumption. Because if a guy, let's say theoretically there was a concealed carrier in that nightclub. And let's say his blood alcohol level was 0.12, which means he's, as far as the state of Florida is concerned, he's really drunk. He's more than 50% over the legal limit. And let's say he shot back at Omar. And let's say he accidentally shot a bystander in the process. Now, I know hindsight's 20/20, but let's say he stopped Omar after he killed 20 people, but he killed a bystander. Now, since we don't know, since we can't travel into the, we don't have time travel, we can't say, oh, he saved over 30 lives. No, he would probably still be prosecuted, especially if he was intoxicated. We'll get to that at the end. But I just wanted to say that Alan's video was the impetus for this, and he's got some good videos up, and I urge you to watch them. So let's get started with some of Brownie's stupidity and dumbass.
But before I start, I want to restate my position because somebody will probably accuse me of supporting an Obama-Clinton style gun grab instead of listening to what I'm actually saying. Now, I've already discussed the Second Amendment and the gun nuts' misguided fetish defense of it in previous videos. So, let me make myself perfectly clear. I am not against the Second Amendment or responsible people owning firearms for hunting, sport, or self-protection. Because once again, despite the fact that almost 90% of Americans want them, Republicans refused to pass reasonable, common sense restrictions on gun ownership because they're bought, paid for, and owned by the NRA.
Where are your references, dumbass? Illustrating that 90% of Americans want reasonable gun control restrictions. Where's your references for that? And if that's true, guess what? Most Americans don't like Obamacare. So that means you're going to drop your support of Obamacare and single payer? Really? Are you? Because it's not really popular. What's the poll on... let's poll Peter. We'll take Peter's money and give it to Paul. What percentage of Paul wants to have Peter's money? Have you polled Americans? What percentage of Americans would like to pay for the health care of people who smoke cigarettes for decades? You got any polling data on that? But anyways, yeah, Obamacare is about as popular as a turd in the punch bowl. So you're going to drop your support of Obamacare, right? Really? Hello? Brownie, you there, little fella? Here's another retard argument from the retard. He says that we have to just accept senseless mass murders with weapons like the AR-15, which are easier to get than a driver's license, so people who want to own such weapons. Now he's copying, the media has, there's a couple stories out there in the media where these idiots were thinking, oh my gosh, we were able to get firearms. Oh my gosh, it was so easy. Well, here's what you do, Brownie. You can film yourself doing this too, retard. Yeah, you guys will find this pretty funny. Oh gosh. Reporters with no felony convictions are buying AR-15 rifles and calling it journalism. And you got the Philadelphia Daily News shocked that no criminal record and you can get an AR-15. Oh my gosh. And then the Huffington Post and the CBS. Oh my gosh. No criminal record and you get an AR-15. It took 38 minutes and $1,030 for our CBS News producer to buy an AR-15 and walk out legally armed. Oh my gosh. Oh my gosh. I bet you people who don't have 12 drunk driving convictions get to buy cars too. And in Huffington Post, it took 38 minutes for us to walk out of a gun shop with a killing machine. By the way, more people get killed with personal weapons, hand and fist, or feet, than rifles and shotguns combined every year. And more people get killed with a blunt object, crowbar, cinder block, every year than rifles and shotguns. So, yeah. Newsflash, Americans who follow the law are allowed to buy a legal product in America. Call the Pulitzer, people. Go in the local gun store. And guess what? They run a thing called a background check. And they did this to me, too. And when they find out, oh, you have no felonies. Oh, you've never assaulted anybody. Without cause, of course. Defending yourself as an... Oh, you've never beat up your wife. Oh, you have no criminal record whatsoever. You're an upstanding citizen. Oh, you get an AR-15. Wow, that easy. Went through a little thing called a background check. So he's copying that off some news stories where these idiots who have no criminal record were astounded that they could get a weapon. Now, if you have a felony on your resume, then you're not going to get a weapon. But an AR-15, but if you have no felonies, amazingly, you can get one, and I've got one. Oh, so if you don't think people should own AR-15s, and I already have one, what you gonna do? Well, you're going to do nothing, because all my guns have killed fewer people than Ted Kennedy's Oldsmobile. So yeah, he's just copying that. He just copies crap off the internet, stupid arguments that he doesn't think about, because well, he's retarded.
But like any right, there are and should be sensible restrictions.
A fundraiser last year, you said this: the Supreme Court is wrong on the Second Amendment. Now, in the 2008 Heller case, the court said that there is a constitutional individual right to bear arms. What's wrong with that?
Well, I think what the court said about there being an individual right is in line with constitutional thinking. And I said in the convention, I'm not looking to repeal the Second Amendment. I'm not looking to take people's guns away. But I am looking for more support for the reasonable efforts that need to be undertaken to keep guns out of the wrong hands.
And the Second Amendment includes an individual right to bear arms.
Yes, but that right, like every other of our rights, our First Amendment rights, every right that we have is open to and even subject to reasonable regulations.
I just want to pursue this a little bit, because Heller, Justice Scalia, he said that the right to bear arms is reasonably limited. He left the door open to regulation. If you're elected president, you're going to appoint the Ninth Supreme Court Justice. Are you saying you do not want to see the Heller decision, the individual right to bear arms, overturned?
No, I don't. But here's what I do want, and I want to be very clear about this. I want the Congress to step up and do its job. I want to get out of the horrible cycle we're in, where we go and mourn dozens, hundreds, thousands of people killed by gun violence. Everybody says, oh, let's pray, let's, send our hearts and our feelings, and then nothing happens. We're better than this. The gun lobby intimidates elected officials. The vast majority of Americans, including gun owners, support the kind of common sense reforms that I'm proposing.
On immigration.
And then the next thing you hear is that somebody has come to that school using an automatic weapon, an AR-15, and using an automatic weapon, using an automatic weapon, an AR-15, using an automatic weapon, an AR-15, and using an automatic weapon, an AR-15.
So you can see how Hillary is adjusting her message a bit now. Tell me how they talk about universal background checks. In California, it's illegal for a private citizen to sell a gun to his neighbor. You have to do a background check. Required no matter what. In Iowa, a private citizen can sell a gun to another private citizen, no background check required. So the gangbangers that are going to kill people, a gangbanger in, say, East Des Moines wants to kill another gangbanger in East Des Moines, passing a law like that, similar to California's law, how is that going to stop him? Because he's not going through the legal channels already. So, yes, Hillary Clinton wants your guns, and Old Fart Rants, all he does is, it's just basically a Hillary Clinton campaign commercial. That's all this retard does, is just copy crap off the television, talking points, and sit there and autistically repeat them in front of a teleprompter. So, we got 2 more items to go over. Here's a bombshell. Will Brownie do 20 videos on this? According to the GAO auditors, ATF, Alcohol, Tobacco, Bureau of Alcohol, Tobacco, and Firearms, failed to remove the names of gun purchases from its multiple sales database and another system called Access 2000, which allowed it to stockpile information on lawful gun owners by scouring the records of out-of-business FFLs, Federal Firearms Licensees. FFLs are required to report to the ATF the names of customers who purchase multiple firearms at once. ATF is supposed to keep the names on file for no longer than 2 years, after which policies require that the agency remove identifying information about the buyers if the firearms haven't been linked to a crime. But for more than 2 decades, so this goes back to the Clinton administration, the agency has failed to comply with the privacy protection policies with regularity, from the GAO report. In September of '96, again, this is Clinton administration. What did Billy Boy Clinton know, and when did he know it? You know who else would have compiled lists of gun owners? Hitler. In September 1996, we reported that ATF had not fully implemented its 2-year deletion requirement. This is to keep it from compiling lists of gun owners. During the course of our 1996 review, ATF provided documentation that it had subsequently deleted the required records and that it would conduct weekly deletions in the future. Similarly, as a result of our current review, according to ATF documentation, in May 2016, the agency deleted 10,041 records that should have been deleted earlier. However, given that this had been a 20-year issue, it is critical that ATF develop consistency between its deletion policy, the design of the MS system, and the timeliness in which deletions are carried out. By aligning the MS system design and the timeliness of deletion practices with its policy, ATF could ensure that it maintains only useful purchaser information while safeguarding the privacy of firearms purchasers. ATF's Access 2000 system was set up as a voluntary way for FFL holders to more easily comply with ATF requests for information. GAO noted in its report that the system works well for in-business FFLs from both a convenience and privacy perspective. From the report, industry members, not ATF, retain possession and control of their disposition records, and according to ATF officials, they may withdraw from A2K and remove the records from the servers at any time. A2K includes a secure user web interface to each of the servers, and ATF may only obtain A2K disposition information by searching individual industry member servers by exact firearms serial number. Through this search, ATF obtains the same information from each industry member as it would otherwise obtain by phone, fax, or email, and in similar disaggregated form. The situation is different, however, for FFLs that have gone out of business and no longer subject to ATF requirements. ATF officials essentially made the decision to gather up the records of defunct FFLs and store them in a government-controlled database. The GAO report noted, beginning in 2000, ATF maintained A2K disposition data from out-of-business industry members on a single partitioned server within NTC and removed the records from the server in March 2016. ATF's maintenance of the disposition records in this manner violated the Appropriations Act restriction on consolidation or centralization. But don't expect the ATF to give up on trying to find ways to quietly patch together a de facto National Gun Owner Registry anytime soon. Just last weekend, ATF Deputy Director Thomas Brandon complained that the agency isn't able to build such a database in plain sight. He said, "There's lots of things that don't make sense in this town, you know," we told CBS, and so, yeah, would it be efficient and effective? Absolutely. Would the taxpayers benefit with public safety? Absolutely. Are we allowed to do it? No. So, yeah, I'm sure the gangbangers in Chicago, Baltimore, Detroit, Compton, Pine Bluff, Arkansas, what's that crappy town in New Jersey? That garbage town. Oh, can't remember the name of it. Those towns. Stockton, California, San Bernardino, Jackson, Mississippi. Do you think the gangbangers there are going to go through the legal channels where they would even be on that database? So, as I've gone over in my previous videos, some of them have all been referenced in this video. The vast majority of people who get an illegal gun and go out and shoot people, they don't go to a gun store, a gun show, or a flea market and get it. So, yeah. So yeah, there we have a National Gun Registry, and he's pretty. This is like the government with the Patriot Act. They are just out in plain sight saying we want to do this, or we're doing this. So, Mr. Thomas Brandon, I think maybe you should be taken to court over this. And will heads roll at the ATF? Is Obama going to come out and do a presser and say we've fired 5 or 6 underlings? I doubt it. So there you go. Be afraid, be very afraid, and you have been warned. One last thing before we get to the main event. Hillary Clinton voted against a legislation in the Senate back in 2005 that protected gun manufacturers from frivolous lawsuits. She's against that. So what she wants to do is make it easy for people to sue the gun maker if their loved one gets shot by some psychopath in Chicago or Baltimore. So, and then we can sue Budweiser for cirrhosis and McDonald's for fat people, etc.
Can you imagine what would have happened in a dimly lit bar with a bunch of drunks pulling out weapons they may or may not know how to use, shooting into the dark and at each other at 2 a.m., the price of freedom, my...
Okay, this is the final part. Back on, let's see, when did I do this? August 11th, I asked Old Fart Rants if he had done any research pertaining to state statutes related to alcohol consumption and carrying a concealed weapon. As you can see, I gave him ample time to answer. If he would have answered, now we went over to one of his friends' channels, Other Dupe Productions, who I've also refuted before. He's a moron as well. He's almost as dumb as Old Fart Rants. Almost. But I think what Old Fart's going to do now is he's not going to debate me on any thread that I start, because then he can't get the peanut gallery involved. And without the peanut gallery, they can't put like 20 comments in between my debate and his. And then that makes it harder for him to make up his own version of the events and then declare victory. So I think what Brownie's going to do is he's going to cut his losses. He's going to, I guess discretion is the better part of valor. But he didn't answer me. Now, if he would have, I would have recorded this. I've done this many times. Now, his lack of an answer indicates to me that he didn't know. So, let's look at Iowa statutes related to alcohol consumption and concealed carry. So, this applies to Iowa's, back in January 1st, 2011, Iowa became a shall issue state. Now, Brownie lives in California, which is a may issue state, which basically, unless you prove you have a stalker or you're a celebrity, you have to demonstrate a need. This like, did Rosa Parks have to demonstrate a need to ride at the front of the bus? No, she didn't. Here's how you can have your concealed carry permit in Iowa stripped from you. While under the influence of an alcoholic beverage or other drug or combination of such substances, while having an alcohol concentration of 0.08 or more, or 3, while any amount of controlled substance is present in the person as measured in the person's blood or urine. So, Brownie, you listening to me, old man? If you think, well, I would like to say this too, if you're a concealed carrier and you're carrying your weapon with you in public, don't consume any alcohol. That's just, don't do it. Don't consume any. If you're going to get intoxicated, don't bring your firearm with you. Be smart. But Brownie, if you think there should be a zero tolerance policy on this, then if anyone drinks half a glass of red wine or has one beer, then they should go to prison. They should go to jail for driving under the influence. If you want to make it, because I know you probably be biased towards gun owners because you're afraid of guns and you don't know how to handle them properly. So if there's going to be a zero tolerance policy on that, then you'd have to do it for driving too. Uh-oh. See, what he wants to do is he wants you to think that every person, this is a projection. Old Fart Rants is projecting here. thinks everybody's an idiot like him, and if there were concealed carriers in that club that Omar Mateen shot up, then they'd probably be drunk, you know, because I guess that's what he would do, because he's that stupid. No, most, I know a couple concealed carriers, and when they're in public carrying their firearm, they don't drink. So if you're ineligible to carry a permit in Iowa if you are addicted to the use of alcohol. So you can read through, I got all the links, you can go ahead and read that, all those statutes if you want. So Florida statute 790.151. Using firearm while under the influence of alcoholic beverages, chemical substances, or controlled substances. Penalties. As used in 790.151 to 790.1572, to use a firearm means to discharge a firearm or to have a firearm readily accessible for immediate discharge. For the purposes of this section, readily accessible for immediate discharge means loaded and in a person's hand. It is unlawful and punishable as provided in subsection 4 for any person who is under the influence of alcoholic beverages, any chemical substance set forth in S 877.111 or any substance controlled under Chapter 893, a lot of legalese, when affected to the extent that his or her normal faculties are impaired to use a firearm in this state. Any person who violates subsection 3 commits a misdemeanor of the second degree, punishable as provided in such and such sections. This section does not apply to persons exercising lawful self-defense or defense of one's property. So if you're on your property and you're drunk off your rear end and somebody tries to kick in your door, it's not going to apply. Now, what about, let's go further. What about being in public? Test for impairment or intoxication, right to refuse. Any person who uses a firearm within this state shall submit to an approved chemical or physical breath test to determine the alcoholic content of the blood and to a urine test to detect the presence of controlled substances. If there is probable cause to believe that the person was using a firearm while under the influence of alcoholic beverages or controlled substances, or that person is lawfully arrested for any offense allegedly committed while he or she was using a firearm while under the influence of alcoholic beverages or controlled substances, the breath test shall be incidental to a lawful arrest and administered at the request of a law enforcement officer who has probable cause to believe such person was using a firearm within this state while under the influence of alcoholic beverages. The urine test shall be incidental to a lawful arrest and administered at a detention facility, mobile or otherwise, which is equipped to administer such tests at the request of a law enforcement officer who has probable cause to believe such person was using a firearm within this state while under the influence of controlled substances. The urine test shall be administered at a detention facility or any other facility, mobile or otherwise, which is equipped to administer such tests in a reasonable manner that will ensure the accuracy of the specimen and maintain the privacy of the individual involved. The administration of either test, sorry to go through this, but we have to, shall not preclude the administration of the other test. The refusal to submit to a chemical or physical breath or urine test upon the request of a law enforcement officer as provided in this section shall be admissible into evidence in any criminal proceeding. This section shall not hinder the taking of a mandatory blood test as outlined in 790.155. If the arresting officer does not request a chemical or physical test of the person arrested, see, Old Fart Rants won't go over this because it takes a while. It takes brain power. If the arresting officer does not request a chemical or physical test of the person arrested for any offense allegedly committed while the person was using a firearm while under the influence of alcoholic beverages or controlled substances like marijuana, such person may request the arresting officer to have a chemical or physical test made of the arrested person's breath for the purpose of determining the alcoholic content of the person's blood, or a chemical test of urine or blood for the purpose of determining the presence of controlled substances, and, if so requested, the arresting officer shall have the test performed. Oh man, who writes this stuff? The provisions of S 316.1932, Section 1, Subsection F, relating to the administration of tests for determining the weight of alcohol, and that's irrelevant. That's legalese. 790.155. Notwithstanding any recognized ability to refuse to submit to the test provided in S 790.153, if a law enforcement officer has probable cause to believe that a firearm used by a person, listen, if a law enforcement officer has probable cause, dummy, to believe that a firearm was used by a person under the influence of alcoholic beverages or controlled substances like pot has caused the death or serious bodily injury of a human being, such person shall submit, upon the request of a law enforcement officer, to a test of his or her blood for the purpose of determining the alcoholic content thereof or the presence of controlled substances therein. The law enforcement officer may use reasonable force, if necessary, to require such person to submit to the administration of the blood test. The blood test shall be performed in a reasonable manner. The term serious bodily injury means a physical condition which creates a substantial risk of death, serious personal disfigurement, or protracted loss or impairment of the function of any bodily member or organ. The provisions of S. 316.1933, Section 2, relating to blood tests for impairment or intoxication are incorporated into this act. Any criminal charge resulting from the incident giving rise to the officer's demand for testing shall be tried concurrently with a charge of any violation of S. 790.151. If such charges are tried separately, the fact that such person refused, resisted, obstructed, or opposed testing shall be admissible at the trial of the criminal offense which gave rise to the demand for testing. The results of any test administered pursuant to this section for the purpose of detecting the presence of any controlled substance shall not be admissible as evidence in a criminal prosecution for the possession of a controlled substance. Notwithstanding any provision of law pertaining to the confidentiality of hospital records or other medical records, information obtained pursuant to this section shall be released to a court, prosecuting attorney, defense attorney, or law enforcement officer in connection with an alleged violation of S. 790.151 upon request for such information. So if you look through the Florida statutes, let's say somebody at the, we don't have hindsight to know, so if somebody had pulled out a gun and shot Mateen but accidentally shot a bystander, that person, even if they shot Mateen, if they killed a bystander, there's a good chance they're going to get charged. If they didn't kill Mateen and they killed a bystander, there's a really good chance they're going to be charged. So Brownie hasn't read through any, that's why he didn't answer me, of course. He hasn't read through any of the statutes. He probably couldn't even find them, even with Google. That's where he gets all his answers from. So no, you're not allowed to go out in Florida or Iowa, get drunk off your butt if the place allows guns in it, because it should be up to the owner. If they don't want firearms in there, they don't have to allow them in. But if you're drunk off your butt and have a .14 alcohol level and you start shooting the place up after someone else shoots the place up, or maybe somebody doesn't start shooting the place up and you're the one that gets unruly and shoots at somebody, you're going to get your concealed carry permit stripped, and you probably will go to prison. So again, Old Fart Rants is arguing from his own ignorance. He often uses projection, and that's what he was doing here, and he uses his own ignorance as an argument. So there, I have all the links below as per usual. As per usual, Brownie didn't have any links in his video, of course, for any of his just so statements, which he does a lot of because he's very sloppy. Even though even though he has 24 hours of free time, he's very lazy. You would think people with all this free time would be a little more intelligent, but he's in this pattern of being lazy and being a bum. So you'll have to forgive him. But go ahead and do some more videos on gun control, Brownie, and then I can correct you again. Have a nice day, and don't thank me now for correcting you with the facts, old man.